Under section 70, admission of a execution by party to attested document. In a case of Jagannath versus Rauji, 24 Bombay Law Reports, 1926, it was held that this section serves as a proviso to section 68. The effect of this section is to make the admission of the executant a sufficient proof of the execution of a document as against the executant himself, even though it may be document attestation of which is required by law. In a case of Rajaram versus Thakur, 12 Lucknow 109, it was held that this section operates only where the person relying on the document has not given any evidence at all of the due execution of the document by the executant, but relies on an admission by the executant of latter. So that if a mortgagor admits execution of a document in the return statement, it is wholly unnecessary for the mortgagee to adduce any evidence as to execution of the document. It is only in a cases where it appears on the face of a document or it is positively made out by the evidence on a record that the document required by law to be attested has not been attested in accordance with the law, that this section cannot be made applicable in spite of the admission of a party to an attested document to its execution by himself, for a simple reason that a court cannot shut its eyes to obvious fact appearing on the face of the document or on the record. In the case of Abdul Karim versus Salimam, 27 Calcutta 190, it was held that admission here spoken of relates only to the execution. It must be distinguished from the admission mentioned in section 22 and 65B, which relates to the content of the document. The Calcutta and Allahabad High Court have held that the word admission relates only to the admission of party in the course of trial of a suit and not to the attestation of a document by the admission of the party executing it. In other words, it has no relation to any admission of an execution made before an attesting witness without reference to any suit or a proceeding. In a case of Nageshwar Prasad versus Bachchu Singh, it was held that Patna and Rangoon High Court have laid down that the admission under this section is admissible in evidence even though it to be an admission not made in the course of a legal proceedings pending before the court of justice, but is an admission made antecedent to the institution of legal proceedings. In the case of Daud versus Ramanath, 1938, Madras 523, it was held that the Madras High Court has adopted the view of the Calcutta and Allahabad High Court and held that admission within the meaning of this section must be an admission made for the purpose of or having reference to the cause either in pleading or during the course of the trial. Under section 71, proof when attesting witnesses denies the execution. The principle of this section implies that where an attesting witness has denied all knowledge of the matter, the case stands as if there was no attesting witness and the execution of the document may be proved by other independent evidence. This section only operates if the attesting witnesses denies or does not recollect the execution of a document or has turned hostile. If the evidence of a witnesses produced by the propounder is inherently worthless and lacking in credibility, Section 71 cannot be invoked to bail him out of the situation. To facilitate a roving pursuit in absence of any touch of truthfulness and genuineness in the overall approach, this provision, which is not a substitute of a Section 63C of Indian Succession Act 1925 and Section 68 of Indian Evidence Act 1872, cannot be invoked to supplement such failed speculative endeavor. Under its execution of the document includes attestation. The attestation of a document does not amount to admission of its content by the attesting person unless it can be proved that the document was read over to him and that he had made the attestation conscious of the statement made in that document. The attestation of a document does not amount to admission of its content by the attesting person unless it can be proved that the document was read over to him and that he made the attestation conscious of the statement made in the document. This section is a sort of safeguard introduced by the legislature to the mandatory provisions of the Section 68, where it is possible to prove the execution of the will by calling attesting witnesses, though alive. This section can only be requisitioned when the attesting witnesses who have been called fail to prove the execution of the will by the reason of their either denying their own signature or denying the signature of the testator or having no recollection as to the execution of the document. The section has no application when one attesting witness has failed to prove the execution of the will and other attesting witnesses are available who could prove the execution if they were called. Section 71 cannot be used to allow a party to go by to the mandate of Section 68 qua the requirement of calling and attesting witnesses, where one attesting witnesses could not be recollect and other attesting witnesses, though available, was not called. It was held that the will was not proved as the mandatory requirement of the section was not satisfied. The principle has to be applied to will. The requirement of calling at least one attesting witness to prove attestation is laid down under Section 68 of the Evidence Act. This section constitutes an exception as it were a Section 68, but the condition laid down for invoking the exception are strict. If the attesting witnesses denies or does not recollect the execution of the document, its execution may be proved by the other evidence. The interplay of the above statutory provisions and the underlying legislative objectives would be formidable relevance in evaluating the material on record and recording the conclusions as held in a Jagdish Chandra Sharma vs. Narayan Singh Sahni's case. The two contingencies permitting the play of this provision, namely denial or a failure to recollect the execution by attesting witnesses produced. Thus, a fortiori has to be extended a meaning to ensure that the limited liberty granted by Section 71 of the Act of 1972 does not in any way, any manner efface or immaculate the essence of the efficacy of Section 63 of the Indian Succession Act and Section 68 of the Indian Evidence Act. Distinction between failure on the part of the attesting witnesses to prove the execution and attestation of a will and his or her denial of the said evidence or a failure to recollect the same has to be essentially maintained. Any unwarranted indulgence permitting extra liberal flexibility to these two stipulations would render the predication of section 63 of the Act and section 68 of the Act OTOs. Propounder can be initiated to the benefit of section 71 of the Indian Evidence Act 1872 if the attesting witnesses who is are alive and who is are produced and in the clear terms either denies or deny the execution of the document or cannot recollect the said incident. Not only this witness or witnesses has or have to be credible and impartial. The evidence adduced ought to be demonstrated unhesitant denial of the execution of the document or authenticate real forgetfulness of such fact.